Thank you so much. After understanding now and getting to ask ourselves individually whether we are married or we presume ourselves to be married, in the context of marriage, may we please now understand what matrimonial property is? Thank you. I'll be inviting my colleague Caroline to take us through it.
Okay, thank you so much. Caroline, kindly take us through the matrimonial and what is the meaning of matrimonial properties?
Okay. Thank you very much for that question. So for matrimonial property, it's provided for under the Matrimonial Property Act. This is property that is acquired when you're married, during the subsistence of your marriage. So when you're married, there's this property you acquire together. It could be movable. Movable are things such as cars. It will be immovable. Immovable is something like land. Also, household goods are recognized as a matrimonial property, and the matrimonial home. That is what is defined as matrimonial property.
Okay, it is also good you tell us how do you define contributions?
Okay. So for matrimonial property, the act comes into effect after you're divorced. So, of course, when you get married, you don't want to get divorced, but there are circumstances that may force you to be divorced. So once you divorce, then you might be required to determine your contribution to the matrimonial property. So for contribution, it's in two forms. One could be monetary. Monetary means, did you provide money to buy this property? The other form is non-monetary contribution. For non-monetary contribution, it is something like companionship. Companionship is recognized by the law. Something like childbirth, something like taking care of the kids, something like taking care of the family home and the family business. That is what non-monetary contribution is. So for all this, if you show that you contributed towards acquiring the property either in a monetary form or non-monetary, they are both legible.
Okay, thank you so much, Madam Caro. Allow me to ask you, does property acquired or inherited before marriage from part of the matrimonial property?
So for property acquired before marriage, the answer is no. It does not form part of the matrimonial property. However, there's a but in law. If the spouse improved upon the property, yes, you acquired it before you got married, but now this spouse has come into your life and has improved upon the property. Maybe if it was a bare land, she's set up a house, or if it was a house, she's even put curtains and furniture in it, then it may form part of matrimonial property.
Okay.
Yes.
Does the Kenyan law cover prenuptial agreements?
Yes, the Kenyan law covers prenuptial agreements. Prenuptial agreements is an agreement that you get into before you get married, and this agreement provides for how you're going to distribute the property in the event that your marriage is dissolved. So prenuptial agreements are covered in Kenya. So you just list down, in case you get divorced, this is how the property should be distributed amongst the two spouses. Yes.
Thank you so much for those answers to the congregants. Thank you.
Thank you so much for taking us through the matrimonial property bit. I will invite our members if anyone has anything to add on it.
I want to add on contribution, and I want to, as much we are Christians and we want to live together in harmony, and that's our prayers, that we go into a union and till death. But life happens, and it also happens to the best of us. When it comes to what my sister has talked about, it's the union may break up for whatever reason. Be prepared for that eventuality, and it will save you a lot of tears at that point. And then contribution is what did you do towards this property? For instance, if it was a property that came, you inherited or you got got married when you still had that property, you also have to show that improvement. You can't just say that I improved. You have to show that improvement. So it is really things that are quite tangible when it comes to contribution. It's something that is tangible. It's not something that you can just allege. And there is nothing, what the law has brought under the Matrimonial Properties Act, there is nothing like our property. And I think when I say that, people get shocked, but there is nothing like our property. Marriage does not confer anybody any rights to anybody's property. You cannot get married and say, we own. That doesn't exist. I'm sorry to burst your bubbles. Yeah.
So maybe I would add to that by asking Carol, now that we understand better what matrimonial property is and what is the scope of this, which is matrimonial property, and what is not matrimonial property in the context of marriage. So, under matrimonial property, do we need consent between the two parties or the three parties in a polygamous setup before disposing any assets?
Thank you, Emily, for that question. Yes, if you're married and you acquire property together, and maybe one of the spouses needs to, maybe let's say, sell the property, then you as the spouse, you need to consent. And I don't know whether you've seen the affidavits that are done where you say, I have no objection to this property being sold. It is a requirement in law that you must give consent as a spouse if the property is matrimonial property. And if consent is not given, then that sale or whatever is illegal, is invalid.
May I also clarify that if the property is in the husband's name and he wants to sell, in this case, when it comes to consent by the wife, it doesn't matter whether the wife contributed zero. The marriage certificate says she has to consent. So contribution again doesn't come in at this point. Consent is given by the spouse. So it looks a bit contradictory, but that's the position.
So that is to encourage us as families to know each other. Let me get to know what my husband owns. Let my husband get to know what the wife owns, so that we get to know our rights, especially where we have to dispose assets or in cases where there is divorce, unfortunately. Thank you.